Hello everyone, my name is Brandon Mikiri. In this video, my colleagues and I are going to be discussing on privacy and confidential information. Our presentation will consist of the following coherent content: confidential information, test for privacy, unauthorized use, disclosure in the public interest, remedies, protection from harassment, and at last, harassment by journalists.
Alright. Firstly, on confidential information, it is defined as any data that a disclosing party offers a receiving party, orally or written, that is meant to be private. So the receiving party reasonably understands its confidential nature and any circumstances that would call for disclosure of said information. For example, confidential information may include financial projections, employee information, trade secrets, and sales. So it plays an essential role in companies as it helps to protect the company from losing its vital information that is necessary for the business success. The law as it relates to the confidential information, it is built upon the equitable principle that a person who has received information in confidence cannot take advantage of it and must not use it to the detriment of the person who provided the information without their consent. However, information can be categorized as confidential when it has the necessary quality of confidence. This requirement excludes information that is already publicly known. Secondly, the information must be imparted in circumstances importing an obligation of confidence. Lastly, there must be unauthorized use or disclosure of the information that is detrimental to the owner or the source of the information.
Privacy can be defined as the freedom from intrusion into one's personal matters and personal information. According to Chapter 4, Section 57 of the Constitution, every person has got the right to privacy, which includes the right not to have their home, premises, or property entered. Secondly, their home, premises, or property searched. Thirdly, their possessions seized, the privacy of their communications infringed, or their healthy condition disclosed. In this regard, according to Protection Act Chapter 14, Section 14, has placed a duty on any person who receives, compiles, retains, or reports any confidential information pertaining to a customer to protect such information. The Cybersecurity Bill is the latest attempt to consolidate and a framework for the protection of personal data rights.
Our attention to the unauthorized use of confidential information. According to the Law Insider, unauthorized use of confidential information refers to the use of information by a person or organization other than the owner or those who represent the owner without actual, implied, or apparent authority for such use and from which the owner do not receive any benefit. In respect of the media, unauthorized use of confidential information is when the media publishes information that is private to the public or third parties, that the publisher knew or ought to know that it gives duty to maintain secrecy, or it was obtained in a manner contrary to honest commercial practices without the owner's express or implied consent.
When we move to disclosure in public interest, a public interest disclosure is the dissemination of information about a wrongdoing in the public sector that serves the public interest. Information will only be disclosed if it serves the public interest, not personal interests. According to the 2013 version of the Zimbabwean Constitution, the head of the public body shall have a duty to disclose information, number 1, to an applicant, number 2, members of the public interested or affected person, whether or not it has been requested. If the information concerning, number 1, the risk of significant harm to the health or safety of the members of public, Number 2, the risk of significant harm to the environment. Number 3, any matter that is in the interest of a public security or public order. Number 4, any information that threatens national security. Number 5, any matter that assists in the prevention, detection, or suppression of a crime. However, before disclosing any information in terms of subsection 1, the head of the public body shall firstly notify any third party who is affected by the dissemination of this information or any relevant authority or the police commission.
2. Remedies for breach of privacy. A remedy is a form of court enforcement of a legal result from a successful civil lawsuit. There are damages, apologies and corrections, and injunction under remedies. And under damages, according to the Oxford University Press 2007, Mohem argues that compensatory damages should be understood as remedying a loss of dignity and autonomy. Interest inherent in all breaches of privacy. 2. Protect, which acts as the justification for the right itself. In the absence of a general cause of action for the invasion of privacy, Whitesburg notes the complaints under the Privacy Act remains as an important avenue for the protection of informational privacy through conciliation as well through determinations under Section 52 of the Act. Moving on to apologies and corrections. The consideration of apologies and corrections is largely limited to Robin Coral's contribution to the volume, which focuses on the two of the proposals contained in the Australian Law Reform Commission's Serious Invasions of Privacy in the Digital Era final report. First proposal is creation of method by the courts which may take account of the apologies and correction as factors in the assessment of damages, consistent with the mechanisms available in comparable tasks such as defamation. The second proposal suggests courts be conferred with the power to order a defendant to apologize or order the publication of a correction where false private information has been published. Moving to injunction. Injunction is a court order requiring a person to do or cease doing a specific action. The plaintiff will be demanding positive interest in certain loss of trust situations, but would rather keep the details completely out of the public domain. This may be done by the injunction order of court, either limiting or depending from doing something or requiring the dependent to do something else.
We shift our attention to protection from harassment of media houses. Journalists have traditionally faced verbal intimidation, physical attacks, arbitrary arrest, detention, interception of communication, and financial pressure at the hands of the police, government officials, and supporters of the main political parties. They are vulnerable to harassment and violence when attempting to cover sensitive events and news or political issues, and have also reported to retaliating attacks and threats. I will give examples on cases of journalist harassment in Zimbabwe. In June 2015, journalist Patrick Chitongo was sentenced to 1 year in prison for publishing an unregistered newspaper, The Southern Mirror, in violation of the IPA. In November, authorities arrested photojournalist Anderson Shadrack Manyere for filming clashes between the police and supporters of the Movement for Democratic Change. Changira MDCT, he was charged with participating in a gathering with intent to promote public violence, breaches of the peace of bigotry. I move on to protection of media houses. Freedom of press is restricted in Zimbabwe. The government has not yet aligned media laws with the country's constitution passed in 2013. Organizations like MISA represent journalists when they are arrested. MISA monitors media violations on a day-to-day basis and is responsible for lobbying relevant authorities so that problems faced by journalists and media personnel are solved amicably and expediently. Training by MISA for media houses to report accurately, analytically, and informatively is also another attempt to protect journalists. There are also some initiatives taken by UNESCO in the field of safety of media houses. UNESCO is partnering with various journalism professional organizations to ensure the safety of journalists. These include Article 19, as an international human rights organization which helps defend and promote freedom of expression all over the world. In addition, Committee to Protect Journalists, CPJ, is an independent non-profit organization established in 1981 to promote press freedom and monitor abuse against press around the world. Free Press Unlimited is also an organization that supports local journalists in war and conflict zones to provide their audience trustworthy information. They believe that information can be life and death importance. Over and above that, the International Federation of Journalists, IFJ, helps promote action to protect social justice and press freedom through free, strong, and independent trade unions of journalists. Lastly, International Press Institute, IPI, is a network of journalists, media, and editors at an international level who aim to improve the standards of the practice and improve the status of freedom of expression.
With regards to harassment by journalists, the journalist privilege, also known as the journalist-shield law, is the right not to be compelled to testify or disclose sources and information in court. Thus, publishing something that is false and negative about a person or public opinion is considered as defamation, which would be a violation to the Human Rights Act 1998. According to the Zimbabwean Constitution, the Access to Information and Protection of Privacy Act, which is Chapter 1027, regards a journalist to have abused his journalistic privilege if he 1. Intentionally or recklessly falsify information or opinion. 2. Publishing any statement, knowing it to be false or without having reasonable grounds for believing it to be true, recklessly or with malicious intent to represent it as a true statement, committing or facilitating the commission of a criminal offense, thus should be guilty of an offense and liable to a fine, although not exceeding level 7 or imprisonment, as this would be a violation to the Section 51 and 57 of the Zimbabwean Constitution.
As a recap, our video is attempted to focus on confidential information, privacy, unauthorized use, disclosure in the public interest, remedies in past cases, protection from harassment of media houses, and harassment by journalists. Thank you.